In the realm of family law, the dissolution of a marriage can take two distinct forms, annulment and divorce. While both serve to legally end a marital union, they operate under different principles and have distinct legal consequences. Understanding the difference between these two legal remedies is crucial for anyone contemplating the dissolution of their marriage. Divorce is the more common approach to ending a marriage. It recognizes the existence of a valid marriage, but acknowledges that the relationship has irretrievably broken down. Annulment, on the other hand, operates on the premise that the marriage was never legally valid from its inception. An annulment essentially erases the marriage as if it never happened. It declares the union null and void, meaning it is deemed to have never existed in the eyes of the law. This differs significantly from divorce, which recognizes the marriage's existence but dissolves it due to irreconcilable differences or other statutory grounds. The decision of whether to pursue an annulment or a divorce hinges on the specific circumstances surrounding the marriage and the grounds upon which the dissolution is sought. Seeking legal counsel is paramount to determine the appropriate course of action based on individual circumstances. A solicitor specializing in family law can provide tailored guidance and ensure that the chosen path aligns with the desired outcome. Annulment, as a legal remedy, rests upon specific grounds that render a marriage invalid from the outset. These grounds are clearly defined in law, and the burden of proof lies with the party seeking the annulment. Understanding these grounds is essential for determining whether annulment is a viable option. One ground for annulment is the absence of essential elements required for a valid marriage. These elements include free and full consent from both parties, the capacity to enter into a marriage contract, and compliance with legal formalities. If any of these elements are lacking at the time of the marriage, it may be subject to annulment. Another ground for annulment involves prohibited degrees of relationship. Marriages between close blood relatives, such as siblings or parents and children, are strictly prohibited by law and are void from the outset. Such unions violate fundamental societal norms and are deemed incestuous, rendering them invalid. Furthermore, bigamy, the act of entering into a marriage while still legally married to another person, constitutes a ground for annulment. Bigamous marriages are illegal and void as they undermine the principle of monogamy upon which the institution of marriage is founded. In essence, the grounds for annulment center around fundamental flaws that invalidate the marriage from its inception. These flaws may pertain to the parties' capacity to marry, their compliance with legal requirements, or the very nature of the relationship itself. Within the realm of annulment, a crucial distinction exists between void and voidable marriages. A void marriage is considered to have never existed in the eyes of the law. It is automatically void, meaning no legal proceedings are required. This applies to marriages that violate fundamental prohibitions, such as bigamy. A voidable marriage is valid until annulled by a court. Grounds include lack of consent and certain mental health conditions. The distinction has significant implications for the parties involved. Void marriages do not require a formal annulment process. Voidable marriages necessitate a court declaration to dissolve the union. Navigating the annulment process can seem daunting, but understanding the steps involved can provide clarity and guidance during this challenging time. While seeking legal counsel is crucial throughout the process, having a general understanding of the procedure can empower individuals seeking to dissolve their marriage. The first step involves filing a petition for annulment with the family court. This petition outlines the grounds upon which the annulment is sought and provides relevant details about the marriage. The petition must be served on the other party, known as the respondent. Upon receipt of the petition, the respondent has the opportunity to file an answer, either agreeing or disagreeing with the claims made. If the respondent contests the annulment, the case may proceed to a court hearing. During the court hearing, both parties have the opportunity to present evidence and arguments in support of their case. The court will carefully consider all evidence presented before making a decision. If the court grants the annulment, it will issue a decree of nullity. This decree legally declares that the marriage was never valid. The decree is a crucial document as it restores the parties to their pre-marital status. Throughout the annulment process, it is essential to maintain open communication with your solicitor and comply with all court directions. Failure to do so could jeopardize the outcome of your case.